After being convicted of a crime, have you ever wondered if owning or carrying a firearm would ever be possible again? What crimes prevent a citizen from exercising their God-given Second Amendment right, and what is the process involved in restoring those rights? That's what we're talking about here today, so stay tuned. If you would like a quick tips cheat sheet to the firearms restoration rights process here in the state of Michigan, head on over to our website, radzwionlaw.com, and on our homepage, if you scroll all the way to the bottom, enter your name, your email address, and then type in the description box gun cheat sheet and click the submit button. I will personally email you the cheat sheet directly to your email inbox. Hello everyone, my name is Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC, and today this post will cover what the court considers to be a specified felony and what crimes are considered not a specified felony. In previous posts, we looked at what a non-specified felony means and also what a specified felony means and what the processes look like for each of those types of felonies. You can find those posts on our blog page, radzwionlaw.com/blog. So let's look at clarifying the term specified felony. The Michigan courts have clarified this term and by saying that a specified felony, they can apply more than just one section of the law, which actually lists out what felonies are considered specified felonies. This area of the law is MCL 750.224 F subsection 10. And one section of the law says that the felony of burglary of an occupied dwelling will be considered a specified felony. Another part of the law says that if a citizen commits a crime that includes the force against the victim, force against another person, or force against another person's property, that crime may be considered a specified felony. It can classify as a specified felony even if it's not listed under the statute. So the question then becomes, what if a citizen committed a crime against an unoccupied dwelling? Well, the court in Tuggle v. Department of State Police, this is a 2005 case, held that physical force against an unmanned or unoccupied property will still categorize as a specified felony. The court reasoned that even though the property was unoccupied and no person was in the building, the crime of burglary has an element of force that's used against another person's property. The use of force against another person's property is an element that meets the statute's MCL 750.224 F10's definition of force or attempted force. In other words, even if a citizen committed a crime of burglary or breaking and entering of a dwelling and the homeowner was not home, the court still may view this crime and classify it as a specified felony because the action of burglary has a breaking and entering requires the use of force on another person's property. Speaking of the use of force, the court has also found that physical force doesn't actually need to have been used, but the threat of force could move a crime into the category of specified felony. The crime of larceny from a person is much like robbery, except larceny doesn't involve the use of physical force or physical violence. But the court in People v. Perkins, and this is a 2005 case, again held that even if no physical threat is used, a substantial threat of physical force or physical violence which may occur, such crime then may be categorized as a specified felony. In other words, a prosecutor may argue that even if a citizen did not use force during a crime, that the manner in which the crime is committed, that the potential for the physical threat of force or violence is there, the prosecutor can argue that that crime should be classified as a specified felony. And this means that a citizen who is going through the firearms rights restoration process, if they have this crime on their record and the prosecutor is arguing that there was this threat of force, the citizen is then going to have to go through the specified felony process rather than the non-specified felony process. And again, those two processes and the difference between them and what the requirements are, we have posted those on our blog page. But what about crimes that are not specified felonies? Do we have any case law that talks about something that maybe a prosecutor was arguing that this crime should be considered a specified felony? What is the court ruled on? There is one case from 2020 in which the court ruled that unlawful driving away of an automobile is not considered a specified felony. But what about preparing a case and going into court or going through the process of restoring your firearm rights? Just be aware that a citizen may have hurdles to overcome. There may be arguments made for why a crime should be considered specified felony, and that argument is made from the prosecutor. You'll also have the attorney for the citizen that may be able to argue why something is not or should not be considered a specified felony. The types of crimes not otherwise laid out in the statute can still be considered specified felonies if the court believes the prosecutor's argument as to maybe something like the threat or attempted threat of physical force or physical violence. And in other words, the ability of the prosecutor to argue these points or argue their position as to why a crime should be considered a specified felony will mean that a citizen's attorney should be prepared to argue the opposite and know what the case law is, know what the statutes are, and prepare a good argument for that citizen and refute what the prosecutor is going to say. If you would like to retain Radzwion Law PLLC as your trusted attorney, please do not hesitate to contact us. We are here to protect you when you need it most, and we will fight for your freedom. Thanks for watching, everyone. Please leave us a comment below, and we will see you next time.